Welcome, everyone. Thank you for joining us. As always, we run our webinars sometimes by ourselves, sometimes with invited guests. This time, our guest is our long-standing partner, Nitesh Patel from Gilchrist Connell. He's a principal and he's specializing in all matters related to privacy, cyber, and technology. So the topic for today is what you need to know about privacy and cyber regulation. But also, we haven't limited just on theory about cyber regulation and privacy. We are going to go quite deep into the practicality of what is actually happening right now on the ground and how the laws and the regulations are playing in real life. So I've got a pretty busy agenda for today. We will go through, first of all, just recap major cyber and privacy reforms from 2025. As you know, last year was big in that sense. Then we will spend quite a bit of time learning the lessons from the court and regulator decisions. So this is where, the regulation has happened, and now this is how regulators are interpreting it and the court decisions that are being handed over to different firms. Nitesh is going to walk us through those. Then we'll speak a little bit about the regulators and what are they doing, so the activity and trends and how people are dealing with this and what they're experiencing. Then what's in store for 2026? We admit there's a little bit of speculation and looking into the crystal ball for this one. And finally, just practical tips, what you can do and, what you've learned from this. All right, so let's start with recap of major reforms. Before I jump in, if you've got questions, as always, just post them in the chat. We'll leave some time at the end to go through them. If you have a question as we're going through something, pop it in and we'll come back to that later. All right, perfect. So let's start with privacy reforms of 2025. Nitesh?
Thank you. As Tatiana said, there's a little bit to get through, so we might speed through some things, but we'll try and focus on the ones that are going to be particularly relevant for you. So with the Privacy Act reforms, technically they came into effect late November. Well, they were passed in late November 2024, but the reality was that they came into force in many respects in 2025, or they really got on the radar in 2025. So it's worth recapping it from that perspective. We won't go through everything as I mentioned, but some of the key ones. The first one was that there's a requirement that's coming into force soon around the disclosure of the use of automated decision-making systems in certain situations. Since that's coming into force in December 2026, we'll touch upon that in more detail later on. The other ones that are really worth keeping an eye on here or being aware of was the enhanced powers that have been given to the OAIC and to the courts really under these reforms. So the enhanced powers included the ability to make codes about the operation and interpretation of the Australian privacy principles. What this means is that from our perspective, it will allow the OAIC to codify some of the decisions that they make rather than you having to go through determinations or their previous decision documents to understand what exactly how they interpret certain things. The other one is the enhanced regulatory powers for the OAIC. This has been big because it allows the OAIC to govern the Privacy Act with a bit more flexibility. And previously it was really around, well, was there a serious interference of privacy? If so, then the OAIC had to go through a whole court process. They had the determination powers, but that was somewhat limited. The Privacy Act reforms expanded that quite significantly. So now the OAIC can take steps in respect of if there's been a serious interference, as per always. If there was something more specific, they can take action specifically for that purpose, which is a lesser threshold for them to meet. They can also look at failures to provide information when they've requested it. That's got a separate ability now for the OAIC to take action. There's also the expansion of powers for the Federal Court and Family Court to issue orders in civil penalty proceedings beyond just pecuniary penalties. So, for example, they can make any order that they see fit, including to address any harms or damage suffered, damages by way of compensation and publication of a statement as well. It expands the authority to require organisations to identify and address harm to affected individuals, including any foreseeable harm. So the OAIC can now tap on your door and go, hey, you need to explain this piece. It also grants the OAIC general investigative and monitoring powers, and also to conduct public inquiries when they've been given approval by a minister. So pretty significant increase to the remit of their powers and abilities. The other one that's taken a lot of focus over the last 6 months in particular since it came into force is the statutory tort for serious invasions of privacy. Now, we haven't seen too much by way of claims made or assertions raised yet on this particular piece. The reason is that it came into force on 10 June 2025, and it only really applies to conduct that occurs after 10 June 2025. So there'll be a little bit of a leeway before we see this come into the general radar and within claims. We've seen one or two, but they've been pretty limited to date because of that restriction as to the conduct it applies to. So what do you need to do to establish a serious invasion of privacy? It will require an individual to demonstrate that there'd been an invasion of privacy by intrusion upon their seclusion or a misuse of their information, or both. They'll need to then demonstrate that a reasonable person would have had an expectation of privacy, that the invasion was serious and intentional or reckless, and that there's a public interest in protecting the individual's privacy, which outweighs the countervailing public interest in the activity that is said to have infringed the individual's privacy. There are a range of defences that might apply. I think one of the big things to be aware of here also is that there isn't a need to establish financial loss per se, because the remedies that can be awarded are very broad, and they include injunctions and summary judgment, correction orders, destruction of misused personal information, etc. So there's a broad remit of remedies that can be applied, in addition to damages if that can be demonstrated. So that's the scope of that tort's note will be broad. So I think we will see more activity in respect of that particular tort going forward. So that's a recap of some of the main pieces of the Privacy Act 5. Moving on now to the Cybersecurity Act, which also came into force in May 2025. The big piece here is around the mandatory reporting of ransomware and cyber extortion payments for qualifying businesses. First port of call here is that it only applies to businesses with annual turnover of more than $3 million Australian, and that carry on business in Australia. Now, this does have extraterritorial jurisdiction. We've had to provide some advice on this particular point. It is a little tricky, and effectively what it means is that if you are operating in Australia and you are from overseas, or you've got an overseas subsidiary or parent, and they suffer an incident, that might actually get caught within this particular legislation. So something to be aware of there. If you then make a payment, then you need to notify the Department of Home Affairs and the Australian Signals Directorate within 72 hours of any payments or benefits being given to malicious actors in response to an extortion demand. The key thing there is that it's not a notification of a ransomware incident, it's the notification of a payment. What do you need to notify about? Well, the notification needs to include the entity that made the payment, including contact and business details of the incident itself, as well as the impact on the reporting business, demands made by the extorting entity, the ransomware payment itself, so how much was it, and other details, as well as wallet info, etc. Communications with the extorting entity about the incident and the demand and payment, and then further details that might be required around the underlying incident, which goes beyond the impact itself.
Just to jump in here, Nitesh, just to confirm, it is legal to make ransom payments. Just saying, it's not prohibited or anything like that. Just
yeah, that's a great question, Tatiana. There isn't a prohibition on making a ransomware payment, but there are a number of considerations businesses should have before making a payment. But yes, it's not just a direct outlawing of ransomware payments, but there are some legal considerations that you need to have regard to before doing that. One of the pieces that was introduced with this legislation was protection, we'll call it. One of the concerns raised around this act was, well, you're asking us to provide this information. How is it going to be used? The intention here is to use this for threat intelligence purposes, and in that respect, the information given voluntarily by businesses will not be used for regulatory purposes. If you fail to notify and you are found out, you could be faced with a civil penalty of up to about $100,000. Now, the current guidance is that that's not going to be imposed immediately. The intention is for a bit more of a conciliatory approach to try and get businesses on board to notify. But if you insist on not making a notification, or if we're talking about a years down the path where everyone is expected to know this, then we can see that penalty likely being applied. So that's really the main piece around the Cybersecurity Act, which came into force May 2025. So it applies now. Tatiana, I'll throw over to you now in terms of the regulator recap, because I know I've kind of thrown around the OAIC, which is the Office of the Australian Information Commission. We've got the Australian Prudential Regulatory Authority, and and we've got ASIC as well. So I'll throw to you to cover off the differences between who they regulate and what they regulate.
Yeah, so when we work with people specifically identifying their obligations, we often come to the Privacy Act and people are looking and say, oh, it doesn't apply to me, so technically I don't have to care about it, right? Wrong. So just describing, in Australia, there are multiple regulators that regulate various things. Let's just double down on financial services. So these three are quite important. So OAIC, I'll just explain the difference when it comes specifically to privacy, not the broader scope of their activities, but when it comes to privacy. So OAIC regulates specifically everything related to the Privacy Act. So as Nitesh was saying, they can enforce it. They can, allege that you have not been compliant with certain sections of the Privacy Act. Then they also, or not also, including the APP 11, the principle, they will see that you are compliant with your data security obligations and notifiable breach regimes, meaning if there's a privacy breach that happened, it's not just ASIC that you need to think of about notifying, it's OAIC as well that you need to notify, or primarily OAIC for that reason. And finally, OAIC will be looking at those privacy breaches that you are reporting. And as Nitesh just said, they've got now bigger powers to potentially start an investigation or a proceedings against the firm if they do not like the way that how the firm is managing those. So that's one. Then APRA is still a player and an important entity in here. APRA is looking at Australian financial system from the point of view of country global risk and stability inside of our financial system. So one of the important things within APRA's remit is CPS 234, so Information Security Regulation, as you know. It is not directly related to privacy, but obviously a breach of a privacy is a direct result of some kind of vulnerability inside of your systems. So APRA will be very interested in those things. As I said, the regulation happens more on the broader strategic level for the firm and broad accountabilities, but also APRA needs to know about any information security incidents within 72 hours. And then finally,
Sorry, Tatiana, just to kind of reinforce what you've said there, that the distinction between the OAIC and APRA is, firstly, APRA applies to the insurance industry and certain APRA-regulated entities as compared to the OAIC, and their focus is on information assets as compared to the OAIC, which is focused on personal information. And as Tatiana said, personal information often is contained within information assets, or might arguably be called an information asset, so there is overlap there.
So I guess personal information is personally identifiable information. So emails of individuals, names, phone numbers, addresses, things like that. And obviously a firm can hold much more than that, right? If the firm holds all kinds of financial data and so on, that would not fall under the personal information.
Yeah, so government identifiers will fall within it, tax file numbers, a whole range of things, health information, sensitive information, among others. Yeah.
And then finally, ASIC. So in my personal view, the descriptions within ASIC guidances and also Corporations Act are fairly vague when it comes to privacy and information security. However, just zeroing in on the relevant ones. So ASIC oversees cyber governance, and risk management. And risk management, especially for smaller entities, is, again, in our experience, a big gap that people often forget or treat almost like half-heartedly. But if you just look at the regulation and the depth of it in other areas and compare it with this risk management, this is one area that's not very well defined in terms of specific requirements towards entities. And that's why it's up to you, the firms, to actually define your risk framework so that it would adequately cover your information security risks, data protection, and cyber. So in addition to that, ASIC enforces market disclosure obligations. So where cyber incidents are material, so if something happened to you, you actually have to let people know, and your clients have to let them know. And obviously, if a company misled the consumers or breached any kind of conduct standards that relate to privacy and cyber breaches, ASIC will be interested in those, and it would fall under their remit to investigate you. We've put together a very, very simple table just in terms of scope and who is governed by what, just to let you know. So as a blanket rule, any firm operating in Australia, as Nitesh says, is covered by OAIC's scope. The exemption that might apply to any firm is a small business exemption, meaning that your annual revenues are below $3 million. And specifically when we come to insurance industry, revenue is not necessarily GWP, okay? So a revenue, for example, for a broker is only what you state on your P&L as your own revenue, not the GWP that kind of pass through you. And the same applies for agencies. If you do not book GWP as your own revenue, then that's the number you need to take. So that's one. So yeah,
and Tatiana, that, and just a couple of things to note around that small business exemption. There are, unfortunately, as with so many things in the law, there are write-backs in there as well. So if you yourself may have annual turnover of less than $3 million, you'll fall within the small business exemption. But then if you're part of a larger corporate entity that does need to comply with the Privacy Act, then you'll actually be brought back into it. So it's worth having a look at some of those write-backs in as well, just to make sure. And the big one for everyone will be that regardless of your size, if you hold tax file numbers, to the extent you hold those tax file numbers and they're impacted in a cyber incident for data breach assessment purposes, then you will still need to comply with the Privacy Act obligations. So just something to bear in mind in respect of tax file numbers.
Yeah, so that's why when we work with people and, they say, oh, it doesn't apply to me and went through all those exemptions, we still suggest that whatever you do and the way you design your risk framework systems, policies, they still consider the Privacy Act at the heart of it and do not deviate from it, just, as a precaution. Then APRA does not regulate brokers and directly does not regulate agencies, but obviously regulates insurers. The way how APRA can slip into your business if you're a broker or an agency, most likely an agency, is through the contract, primarily through agency agreements with insurers. Some brokers will have the contracts as well, but as we know, probably it's rather an exemption than the rule. And finally, ASIC regulates everyone. So no exceptions, no nothing here. All right, cool. Let's go into the practicalities of what we've learned from recent court decisions.
Thank you, Tatiana. And yeah, there are a couple of pretty significant decisions handed down by the courts in 2025. Many of them in the end by way of consent judgment. And this is one of those trends that you will see that the regulators are looking for test cases. And when they look for test cases, they look for the scenarios where they consider there to be very obvious deficient conduct, to then give them an ability to bring claims or court action. So the first one that I wanted to touch upon was the OAIC and Australian Clinical Labs. It is a landmark decision because it's one of the first scenarios where there's been civil penalties ordered under the Privacy Act. It's also one of the first ones where they've looked at a whole range of things. We'll get on that on the next slide, but a whole range of things around, well, what does it look like when you fail to comply with your obligations to protect personal information? What does it look like when you've failed to notify in accordance with your obligations and failed to assess an incident in accordance with your obligations? But the first place I wanted to touch upon, and if we could go to the next slide, Tatiana, is the chronology here, because there's a lot of really interesting learnings from the chronology itself and then what the outcome was. So we've got the first date there as 25 February 2022. I think the reality is that the first date there should be December 2021 and perhaps earlier. So Medlab, which is the business that was subject to the ransomware attack itself, was acquired by Australian Clinical Labs in December 2021. Now, one of the issues here was that Medlab's cybersecurity was pretty deficient, and it may have been picked up and taken on as part of the risk when ACL acquired the business, but they effectively purchased Medlab. Then they started putting together a plan of action, which I understand was in February. They'd had a plan of action in February 2022 to uplift their cybersecurity and their privacy and the like. But before that could happen, in February 2022, Quantum Group executed a ransomware payload and made a ransom demand. ACL, in response, engaged a company called Stickman Cyber to investigate the incident. Their specialty is around forensics and looking into collecting data and determining, well, how'd they get in and what the incident is, among other things from what we read. To 15 March 2022, Stickman Cyber assessed that they couldn't determine if data had or had not been exfiltrated, stolen or taken. And the reason for that was because they didn't have sufficient, what we call forensic artifacts. They didn't have sufficient information from the systems to be able to determine what actually happened. To give you an idea of the extent of the deficiencies here, the available logs in certain respects only went back half an hour or an hour. So you ordinarily expected to have much longer in terms of information about what happened. They only had a very short period of time. So Stickman Cyber determined that they couldn't determine if data had been exfiltrated or not. And then on that basis, they said to ACL, oh, look, can't determine that there's been data exfiltration, so you've got a basis to determine that the incident was not an eligible data breach. Now, that's a bit of a no-no generally in terms of how you treat scenarios where you have insufficient forensic information, and so you've got a gap in your understanding, and that's consistent with OAIC guidance. But ACL effectively concluded on that basis also that the incident was not an eligible data breach. 4 days later, the Australian Cybersecurity Centre, so the Australian Threat Intelligence, came to ACL and said, look, I think you've been subject to a ransomware attack. The ACL CIO responded saying, yeah, we're aware, we've investigated, and nothing new, just reliant on what they were aware of before. 16 June 2022, 86 gigabytes of data was published on the dark web. Again, the Australian Cybersecurity Centre notified ACL of the data publication, at which point you'd expect ACL to have some level of panic stations. They immediately looked into it. They identified there was credit card and personal information impacted. They then started taking steps, unfortunately, a week later, to get legal advisors on board to look into the information and identify what personal information was impacted. They then notified the OAIC of the incident on 10 July 2022, and then on 27 October 2022, they notified 223,000 individuals. Well, they made an ASX announcement and a website publication, and they notified over 223,000 individuals had been impacted by the incident. Naturally, that timeline is not great. There is an expectation that once you become aware of an incident, you take all reasonable steps to investigate the incident to determine whether or not it's an eligible data breach within 30 days of becoming aware. Here, even after ACL were made aware on 16 June 2022 that there was data publication, and even where they then identified very quickly that there was personal information impacted and credit card information had been impacted and been disclosed on the dark web, it took them until 10 July to notify the OAIC. So this brings an important distinction between how long there is between that 30-day time frame to assess an incident and what your actual notification obligations are. So your notification obligations are to notify as soon as practicable after you've assessed the incident to be an eligible data breach. So that doesn't mean you've got 30 days. It means if you've got grounds after 2 days to go, yeah, this is an eligible data breach, you have to notify as soon as it's practicable thereafter. So that's an important thing to be aware of here. The OAIC naturally then started investigating this incident, found significant deficiencies in the steps that were taken to protect personal information, and then commenced proceedings. So if we go on to the next slide, the court found significant and extensive contraventions by ACL on account of failures to take reasonable steps to protect personal information in accordance with their obligations under APP 11.1. There was significant failures to comply with breach assessment and notification obligations as well. The case itself, we won't go into minutiae in terms of the extent of the deficiencies that were identified by the OAIC, but the case does give you a good amount of detail as to what the OAIC said were deficiencies in this scenario in terms of the reasonable steps to protect personal information. Some of it's very obvious, some of it might be a bit of a surprise in terms of the extent of what you expected to have in place. It's worth having a look. But one of the things that you also want to have regard to is the OAIC will have regard to your means. So how big are you? How much do you have to dedicate towards protecting personal information? That is one of the relevant factors here. Here we're talking about a very large business who deal with sensitive health information, and so the expectations were fairly high in terms of what the reasonable steps to protect personal information should have been. So the court issued a civil penalty of $5.8 million plus costs. That was broken down into $800,000 for breach assessment failures, $800,000 for breach notification failures, and $4.2 million for failures to protect personal information. Something that the court also clarified here was one of the pieces that has been somewhat unclear is, well, if you've got a contravention of your obligation to take reasonable steps to protect personal information, is that, and it affects 1,000 individuals, is that a contravention on a per individual basis, or is that just one contravention? Because that then impacts the theoretical maximum penalty that could apply. The court found here that the breach of APP 11.1 constituted a serious interference to the privacy of each individual affected. So that's 223,000 breaches. And so you get to that theoretical maximum penalty there, which is 495 billion. Now, the court will most likely not award that, but it gives you an idea that the extent of penalties here can go well beyond the theoretical maximum penalty of one serious interference of privacy. And the court did give a good explanation, or a good sounding out of what they took into account when determining that $5.8 million was appropriate in this particular scenario. From our perspective, the next, you wouldn't want to be the next business who in the court might be slightly less sympathetic in terms of the extent of the civil penalty that they may be looking to award. So a lot of learnings from the OAIC and Australian Clinical Labs decision, including around what you should be thinking about when you're looking to acquire a business. I think that's one of those lost pieces in all of this, that this was an acquired business by ACL, and they took on this risk, and then and that's ultimately culminated in this situation for them. So the next decision that I want to look at, and it's in contrast to Australian Clinical Labs, is OAIC and Vinomofo. So this is another situation where the OAIC commenced investigations as a result of the notification of a cyber incident. Vinomofo suffered a ransomware incident on 25 September 2022 that involved data exfiltration from a database. The database held gender, date of birth, contact information, sales order information, and invoicing, but no credit card details or other information of that nature. It was for almost 1 million people. The Vinomofo, the OAIC started making preliminary inquiries, and then the responses that they received raised concerns for them as to the extent to which Vinomofo were complying with their obligations to protect personal information, which then led to an investigation. So if we go to the next slide, the OAIC made declarations here that Vinomofo had interfered with the privacy of almost 1 million individuals because they failed to take reasonable steps to protect personal information as required under APP 11.1. They determined that that Vinomofo was required to, among other things, take steps to improve the security logging, access settings, monitoring controls, and systems, policies, and procedures, independent staff adequacy assessments, and internal privacy culture. They had to do that within 90 days. They had to engage an independent reviewer to review the effectiveness of the above measures and prepare a report within 6 months. They had to provide a copy of that report to the OAIC and then action any recommendation made in that report within 90 days. So a pretty comprehensive arrangement had to be adhered to around uplifting the security measures in place at Vinomofo. There's a couple of points here. Firstly, when you look at that information in and of itself, it may not immediately feel like it's overly sensitive. We've got gender, date of birth, contact details, and sales order information. So ordinarily, there'd need to be some sort of phishing campaign or something more in terms of identity theft or financial harm to be perpetrated against those individuals. But the OAIC had regard to the fact that all this information was in one database, was in respect of over 1 million people. It was structured, ordered, easy for someone to utilize and manipulate as required. And for that reason, they said that there need to be significantly more measures in place to protect that personal information. So it's not just how sensitive the information in and of itself in a granular basis is. You need to have a look at your whole database generally and what could happen if it's taken as a whole. The other piece to look at here is the difference in outcome between what happened in Australian Clinical Labs, where there wasn't a notification, where the assessment wasn't undertaken in the manner that you'd expect, compared to what's happened with the Vinomofo decision. Yes, they need to uplift their security. Yes, there was a determination made, but it wasn't the outcome of a significant penalty and the like. One thing that Vinomofo did raise in all of this was, well, hang on, APP 11.1 doesn't specifically refer to technical and organizational measures needing to be in place. That's a new requirement that came under APP 11.3. So in the 2025 reforms, APP 11.3 was introduced, and it said that APP 11.1 requires technical and organization measures to be in place. The OAIC clarified that the requirement for APP 11.1 requiring technical and organizational measures to be in place, that's not a new requirement. That's always been in place. APP 11.3 simply clarified that that was the position. The other thing to note here is that the OAIC acknowledged that some steps were taken, but that these are insufficient in terms of protecting and in terms of reasonable steps to protect personal information. So there was only a limited ability to monitor, detect, be alerted to, respond to, and record suspicious activity or incidents. So that threat monitoring piece, a failure to apply appropriate security controls. Again, the OAIC took the view that that database was sufficiently sensitive to require additional security measures. And the other piece was they were quite critical of the culture and business posture as to customer privacy generally. So one slip up can then result in an investigation of your whole business practices when it comes to personal information, something to be aware of. All right, the next piece we want to go to, and we'll touch upon this briefly because there's another decision that's actually come down and that we'll talk about that came out in the last few days actually involving ASIC. ASIC's probably been the most litigious of the regulators to date, something to be aware of, and they've had probably the best outcomes to date as well. So they commenced proceedings against Fortnum in 2025. The allegations are similar to what you saw in ASIC and RI Advice, which is they failed to properly manage and mitigate cybersecurity risks, which is a contravention of Section 912 capital A of the Corporations Act, including in respect of adequate risk management and providing services efficiently, honestly, and fairly. So this is important in so much as what Tatiana was talking about earlier around the fact that there's no specific reference to cybersecurity risk management in the relevant legislation that ASIC is relying on here. Section 912 capital A relevantly says you need to have in place adequate risk management. The court cases, ASIC and RI Advice, and ASIC's view is that adequate risk management also includes adequate cyber risk management, which is the basis upon which they're bringing a lot of these proceedings. If we move on to the next slide. The relevant background here is that from January 2021 to May 2023, multiple authorized representatives of Fortnum experienced at least 5 cyber incidents, the most significant of which involved data of 9,000 clients being published to the dark web. So another thing to be aware of here is that what tends to bring you onto ASIC's radar at the moment is you suffering a major cyber incident, which has resulted in notifications to clients or publication of data. In almost all instances where we've seen ASIC take significant action, it is that trigger that then causes them to take further steps. So ASIC alleges here that the cybersecurity policies in place at the relevant time were inadequate. There was insufficient training of authorized representatives by Fortnum. There was no adequate processes, systems, or frameworks in place to oversee the risk and resilience of ARs. Insufficient resources, and we'll talk about that in another case very soon, and inadequate risk management systems in place. So that last piece here, similar allegations have been made, or we should say were made, by ASIC in court proceedings against FIG Securities. So in a little bit, we'll talk about a decision that's actually been handed down against FIG Securities, which has involved a pretty significant penalty, and we'll talk about that one in more detail in a moment. So then the last decision that I'll just touch upon here, because I thought it might be relevant to anyone who's looking to introduce any new platforms or technologies that will involve the use of personal information. The OAIC is cracking down on new technologies and how they're being implemented, especially where they're going to involve the use of personal information. There are 2 decisions here, but we'll focus on the Kmart decision. Kmart used facial recognition technology in 28 of its stores. The purpose of that was to limit losses and refund from refund fraud and to protect staff from violent individuals. It involved the capture biometric processing and storage of multiple images via CCTV of every person. Now, Kmart did display a privacy poster at entry points to alert its customers, but the OAIC raised concerns about the use of the facial recognition technology and commenced their investigations. Ultimately, the OAIC found that Kmart had interfered with the privacy of individuals without their consent. In doing so, they said that this wasn't reasonable and necessary. This facial recognition technology was not reasonable and necessary in the circumstances, among other deficiencies in how Kmart undertook this. They said that the collection and use of biometric data was not reasonable as the benefit gain was disproportionate to the impact of the rights of individuals. We'll touch upon a slight shift in this position, again, from a decision that's happened in 2026, quite recent. The facial recognition technology breached multiple APPs around collection and notice, as I mentioned, and Kmart were ordered to make a public apology, publish the OIIC determined, and how to make a complaint, and then destroy collected personal information after 12 months. Now, the reason why they've said destroy the collected personal information after 12 months as opposed to immediately was that they wanted individuals whose personal information has been impacted to inquire about that personal information and take Kmart to task. So it may not make sense initially, but that's the reason behind it. So those were the key decisions I want to touch upon in 2025. There are a number of others, but they're the key ones that we want to touch upon, and there's a number of learnings from that. So now on to regulator trends. So as you can see from 2025 recap, regulators were significantly more active. They are looking for test cases. They're looking to make examples, looking to provide additional guidance as well. I think that's an important piece through all of this, that it's not just about taking businesses to task, it's actually demonstrating what you need to be doing to comply with your obligations. That's one of the key takeaways here, that there's more guidance than ever around what you should be doing, which can be very helpful. You can see that the OIIC, we've talked about the Bunnings determination here. Bunnings determination is in line with what happened with Kmart around the use of facial recognition technology, but there's been a decision recently on that. Australian Clinical Labs, we've talked about. Optus class action proceedings, that's still on foot. Medibank class action proceedings, that's still on foot. The Vinomofo determination we've talked about. We've talked about Fortnum. We'll touch on FIG security. So ASIC have been active. There is continued scrutiny by the OIIC of notified incidents and incidents reported in the media but not notified to them. We had a few of those last year, and there was a reasonable basis for the particular clients to not notify. But regardless, OIIC came knocking, saying, what's happening here? The extent of questioning that is being raised by the OIIC once you make a notify has increased. They want to know more and more about the incident, how it happened, why it wasn't stopped, what are you going to do in the future to prevent future scenarios of this nature. But having said all that, there does seem to be a bit of a resource stretch at the OIIC, and they are looking for opportunities to close files early when it makes sense for them to do that. At times, it can be as early as before data mining has been completed where you've had a cyber incident. The key to all of this is to making sure that you have timely and proactive regulator engagement, where you're demonstrating you understand your obligations, you're getting on the front foot, you're explaining what the path forward is going to be, what the timeframes are going to look like, and that it all adheres to what the OIIC thinks is reasonable. They can close their files early and let you just get on with what you need to get on with. If you don't do that and you're uncooperative, that's where you can start seeing problems. Of course, the larger you are as a business, the more likely you are to face some scrutiny. But the long and the short is that if you are subject to an incident, you get on with assessing it properly, notifying it properly, and being proactive and making sure you provide appropriate responses. It's important that you do that to limit your exposure. All right. So then, what's in store for 2026? Firstly, automated decision-making disclosure obligations. They are going to now come into force on 10 December 2026. Organizations need to meet transparency requirements in respect to the use of automated decision-making systems. What does this mean? Well, APP 1.7 will require disclosure of the use of ADMs that use personal information that may substantially or directly affect the rights of individuals. APP 1.8 requires disclosure of personal information used by the ADM and the decisions made solely by the ADM. You need to set this out in your privacy policy. One of the key things that you need to be aware of here is that this goes beyond the use of generative AI or AI. Automated decision-making has been around for some time. You need to think about what type of processes you have in place that are automated in nature that use personal information, and especially where there's no ability for an individual to contest the decision. It's kind of, they'll put their information into a form or the like. It goes through some sort of tables in the background, and then an answer is spit out that then affects them. That's an example where.
Yeah, a good example is an underwriting agent. So whoever is using automated underwriting, no matter if you're using AI or not, it's a direct application.
Yeah, exactly. Yeah, thank you, Tatiana. Yeah, so it's more than just AI. You need to be looking at this holistically, and that's in the context of the OAIC focusing on business compliance with privacy policy obligations. Now, they've indicated initially that it's going to be in respect of certain industries. Insurance wasn't one of them. But having said that, now that they've started looking at a whole range of industries, there's no reason to see why they would stop there. Part of the requirements here is to update around the use of automated decision-making systems. And one of the pieces that was scrutinized in Kmart, for example, and we'll get onto this in a moment, Bunnings, was that the use of facial recognition technology wasn't properly disclosed in privacy policies. So you need to have a look at your privacy policy compliance as well. It's a good thing to be doing that in 2026, especially when you're looking at it from the ADM perspective. There's going to be more decisions to come, as we've kind of indicated already. There's already been 2 significant decisions in 2026, and we're only just into the second month. So we'll touch upon ASIC and FIG Securities in a moment, but the Bunnings determination builds upon what happened in Kmart. Bunnings had a similar outcome, received a similar outcome from the OAIC. They contested that, and Bunnings succeeded in one key area, in that a administrative decisions tribunal actually agreed with Bunnings, that's saying that no, this whole use of facial recognition technology to protect staff from violent individuals was reasonable, and it fell within certain exceptions to APP 3.3 around using personal information for a reasonable purpose. So they succeeded on that. However, there were still issues around their compliance with APP 1, around the disclosure and use of the facial recognition technology, as well as the notice of collection, so APP 5. So while they got up on, well, it's reasonable to use it, the way they were using it and the way they were disclosing it needed to be improved. So that was good in one sense, but again, providing great clarity around what you need to be doing here in these situations. ASIC have going to continue doing their thing. We'll say in summary, they've made it clear that in 2026, some of the key issues for them are going to be data breaches, operational resilience, crisis management, the use of generative AI and AI technologies, and making sure that all complies with your Section 912 capital A obligations. And the last piece is further Privacy Act reforms. So ASIC and FIG Securities being the last of the very significant pieces here. There was a judgment handed down very recently. Again, it was a consent agreed judgment, just as with Fortnum. And if we go to the next slide, please, Tatiana. 19 May 2023, FIG suffered a cyber incident that resulted in 385 gigabytes of data being exfiltrated and published on the dark web, which included client personal information and data. Now, this actually affected about 18,000 individuals, and it required notification to those 18,000 individuals. One of the things that's relevant here is that FIG held about $3 billion in client assets under management at the relevant time. So they had significant funds under management. That was something that the ASIC had regard to when considering what they were going to do here. They looked into this, they investigated, and again, they commenced proceedings against FIG Security, asserting breaches of obligations under Section 912 capital A. So it was in respect of having inadequate risk management, but also having insufficient resources as well. So it wasn't just inadequate risk management, it was about insufficient resources. And one of the overarching pieces they tend to include in all of these cases is that as a result, they weren't able to provide their financial services honestly, fairly, and efficiently. Again, another obligation under capital A. ASIC alleged that FIG failed to protect itself and its clients from cybersecurity risks, didn't have in place sufficiently and appropriately configured firewalls, didn't have in place a patching plan, didn't update and patch software, didn't have a security information and event management, so a SIEM software on its network, failed to provide mandatory cybersecurity awareness training to staff, and then didn't have adequate human technology and financial resources to manage cybersecurity. And here they left it to their CFO and an internal IT team without IT security expertise. ASIC said this was not sufficient. What is very instructive here is that connected to the court proceedings or court pleadings by ASIC were 2 schedules that sets out the extent of what ASIC said were the deficiencies here for FIG Securities. It's a bit of a template again of sorts, noting again that it's dependent on the size and means of the business, of what ASIC expects you to be having in place to have adequate risk management when it comes to cyber risk management in scenarios like this.
Can I just jump in very quickly? So on those resources point, we work with a lot of firms that do not have anyone in-house looking at technology because everything's outsourced. And maybe a question to Nitesh, what's the obligation in that? I mean, the way we interpret it is the oversight, but maybe jump in with your legal hat on.
Yeah, look, and this is one of those things that's been touched upon in the judgment. So yeah, great question, Tatiana. It's, if you don't have the internal resources, that's fine. You need to have someone external guiding you and advising you. So you need to have a handle on it, but you need to have the appropriate expertise around you to make sure you're doing what you need to be doing to have adequate risk management. So it doesn't have to be internal alone, but you need to have someone there advising you, if it's external, around your risk obligations. I suppose one other piece though I didn't mention that was on the first slide, $2.5 million penalty issued to FIG Securities, as well as $500,000 in ASIC costs to be paid. And they again need to undertake a comprehensive compliance program using an independent expert to incorporate those matters in those schedules. So again, instructive of what ASIC expects. Last piece very quickly, this is speculative in nature. We do foresee at some point there being additional Privacy Act reforms. When that will be remains to be seen. The points here that we've got are matters that have been on the radar for some time, and there's every indication that these will eventually be introduced. It's just a matter of when. No specific guidance that it's going to be this year, but every prospect that at least some of these will be in the near future. The one to keep an eye out for, especially for those who are smaller in size, is the potential removal of the small business exemption. So that's an overview of what's in store for 2026. And I suppose over to you, Tatiana, in terms of the takeaways.
So we've tried to kind of keep them brief, but obviously if you think about it, it's a big systemic issue. And even you've seen 3 different regulators with 3 different mandates intersect very much at the same topic. So our recommendation is to not do piecemeal, not just try to look at one little thing, the passwords or data or something. Just start with big kind of systemic things like your risk management. So just look at it again, and at least in our practical experience and observations, especially for non-APRA regulated entities, this seems to be learning, and people, especially since CPS 230, since that became, a conversation, operational risk management, this very much falls into that remit. So our suggestion, and kind of think about zeroing in on your risk as a general, like how do you manage your risk, but inside of those risks on your core technical infrastructure, and specify your data, cyber, and technology related risks, and be creative. You have to define what they are. But just to give you a sense of it, Australia, and we've just been checking the ranking of Australia globally. There are different perspectives on that, but one source that we found said it's a 10th globally targeted nation in the world. I think we came from number 3 to number 10, which is probably a good thing, but nevertheless, your inherent risks by operating in Australia and dealing with data are very, very high. So it's just a matter of specifying them and finding a good set of controls, real controls, to mitigate them. And as Nitesh was mentioning, some of those controls will be process related, like segregate access to data with different employees, train them on privacy matters, and some of them will be very, very hardwired. So for example, installing multi-factor authentication systems, moving data on different servers, or adding extra security to how it can be accessed and used. So that's one, that's kind of your risk management. Just look at it holistically. Second, obviously, zero in on data. And key to that is, obviously, the OAIC and privacy principles, they regulate personal data. However, you also have, your own business sensitive data. So knowing where it lives and who has access to that is actually very useful. And interestingly enough, not everybody knows it. Even the very, very senior people in companies might not have an idea where it is and how it's being protected. So yeah, think about protections for that very, very sensitive data. I'm pretty sure that large companies have at least better processes around it, which, it's a good thing, being regulated by APRA and having CPS 234 as a mandatory standard. But smaller businesses usually have, potentially gaps in there. And then finally, the big one, which Nitesh addressed too, is automated decisions. And insurance industry is very, very big fan of automated decisions because, that's how we save money on underwriting. That's how we could potentially save money on claims. ASIC remains unwavering about a human is accountable for any decision that's made for the customer, even if a technology made that decision. So understanding how your algorithms work and avoiding black boxes. Unfortunately, again, the technology is getting more complicated and a lot of people do not understand what goes in and why something comes out. So having a clear track record, especially if you start experimenting with AI, you need to know exactly why it assesses something in this way or the other way. And it's almost like a hygiene on top of everything that the hard work that you're doing, rethink your documentation and your processes around it. So, a lot of people go down the path of certifications or standards like penetration testing and ISO and all the other ones. They are good frameworks to identify your risks and to establish processes around them. A lot of firms don't have to do it, but I've seen people at least nearing the standard, if not getting the final certification, but at least adopting the framework of going there. Then, as I already referred to, black boxes, big risk or danger happening, especially, as I said, with AI. And finally, critical documentation. So yes, privacy policies will need a review for sure before the end of this year for, I would say, almost anyone. And then any kind of other documentation, information security, cyber incident responses, and so on. So it's kind of very brief. Obviously, you can create a very, very long list of things. I will pause here and just have a look at if we had any questions. We've got 5 minutes.
And one other thing to raise, Tatiana, in addition to all that, is that it's not enough to have a document that's called an incident response plan or a privacy policy. You need to be reviewing that regularly, and you actually need to know what it does and how to execute it. It is one of the things that the regulators have raised as being insufficient. Just because you've got a document, it needs to be up to date, and it needs to be tested. If you haven't tested it, that's not sufficient.
We've got a question, Nitesh, and I believe that one's for you. What industries are being targeted by ASIC?
All right. So look, in light of what happened mid last year to the superannuation to the superannuation businesses, superannuation is very much on the radar for ASIC. They've and also traditionally taken a liking to the financial advice space as well. But the reality is ASIC is looking at all businesses that they regulate. So while they're focusing at the moment, it seems, on superannuation and financial advisors, there's absolutely no reason to think that they wouldn't take some other business that they regulate to task, including an insurance business, if there's been a significant incident that they've suffered that has then caused flow-on effects. That seems to be one of the big triggers for ASIC and for regulators generally. When there's been a major incident, that will then draw their attention to you.
Okay. Any other questions? We'll give it a minute. Some people tell us, oh, you switch it off too early. Okay, doesn't look like. So thank you so much for joining today. We have kicked off this year earlier with what's in store for 2026 regulatory-wise. We focused on a lot of industry codes. Our next webinar is going to dive into the ASIC updated regulatory guidance on conflict of interest and others. And if you have specific topics or questions that you would like us to address, either drop us an email or put those topics in the chat, and we'll keep providing you with useful information throughout the year. All right. Thanks, everyone. And sorry, one note. For those who watched this webinar from meeting rooms and so on, just drop us a note because we wouldn't know who you are. And when we issue a certificate, we actually need to verify that you've been with us. All right. Thank you so much. See you at the next one. Thank you, Nitesh.